what are the characteristics of a DPIA? So the DPIA will first describe the nature, scope, content, and purpose of processing. So any data protection impact assessment opens, you write the name of the organization, the business ID of the organization. Then you describe the nature of data it's processing, the scope of data processing, that for what purposes are you processing, and also the context, that why are you processing the data, what do you want to really achieve with this data. After you're done with the first part, you come to assess the necessity and proportionality principle. Why is it necessary to process data in this particular way? Are there any less intrusive ways of processing data? You say no. And that is why you're processing data this way, because it's absolutely necessary to process this data to get the purpose you're looking for. And then the proportionality, whether the rights and liabilities are balanced, whether individuals' rights are balanced or not. After that, you talk about the compliance measures you have taken. First is that, and the compliance measures will come under your organizational and technical measures. That what have you done? In this example of where a bank has these people and the bank is storing data of these people, you can say that the data is being stored in an internal unit, and it only people from the bank can access it. Nobody from outside has access to that data. Then the data, when it goes inside, it is encrypted, and only certain risk managers or certain privacy managers can have access to that data. Or when the data goes in, it comes out in form of a number. For example, the data is stored and the investment center wants to contact that particular customer for investment advisor. They will have a number for a customer, 12349, something like that. And that's the customer ID, and that's the customer ID. The customer has also been asked that you do not tell your number to the investment center customer care person. Just give them your customer ID, and that's how you all talk with the customer ID. You give a mail, you write the customer ID. You do not write your name. You do not write your credentials. However, your mail ID will definitely have your name. So, but the bank is, when you're talking on the phone, you just tell your customer ID, and that's enough, right? So these are the some compliance measures that can be taken. The data is encrypted, the key is within, or the data is deleted after a while. The data is retained in certain format, and then it's deleted after a while. Then you have, after you've done all these things, you all identify and assess the risks to individuals. However, I would say that assessing risk would come before writing the compliance measures. I think the slides have. You identify and assess the risk first. So that what are the risks in this case? First you talk about why is it necessary to process data in this case, and what are the measures? How is it proportional? And then you identify the risk in that case. That what are the risks if I keep processing data this way? And then what are the measures, compliance measures that we have taken? And then you come to additional measures that you have taken. So all the data processing agreements have additional measures format. These additional measures are measures taken to, mitigate the risk. And they will range from one organization to organization. This additional measure is also part of organizational and technical measures that is being taken, that you have in your organization. And this is the whole format of your data processing impact assessment. It talks about the data, nature, purpose of processing, the necessity and proportionality. You identify the risk that is being caused to this data. Then you talk about the compliance measures that will be taken. Then you identify additional measures that you have taken to mitigate the risk, to bring the organization within the risk appetite. You do all that. And then at the end, if there is some residual risk, and you say that there is this residual risk and we are accepting this risk, so you also mention that this is the residual risk and we are accepting this risk and we're going to move forward with it, with accepting this risk. To assess the level of risk, you must consider both likelihood and the severity of any impact on individuals. So when you come, will it be risky or not? You have to consider that how severe the impact will be. Right? you have to see that how likely first it is that the risk happen, that the breach can take place, right? How good are your organizational and technical measures? How good are the measures when you're transferring data from one place to another? Then you see that if this risk, if this data goes out, how severely it can impact an individual. For example, in the Vastaamo case that happened in Finland, uh, the data of from a psychiatric ward was breached, and data of a lot of people who had very, very sensitive personal information that was out there in the open. So this was very high risk. And how were they protecting it? They were not protecting it. It was just on the psychiatric ward system. So when you have such data, you have, as a privacy officer, you have to consider what is the likelihood. In today's world, there's huge likelihood of getting all kinds of data breached, and there are lots of breach attempts all the time. So you have to see that are my firewalls, or are the firewalls in an organization strong enough to protect this data? Are these data encrypted that even if it is lost, they will not be able to find out the actual person? Is it pseudonymized, or is it just made in anonymous form? You don't write the name, address, age, anything of the person. You just write that this happened, and that's it, nothing else. That's all that is there online. And then that's anonymous data. So that falls outside GDPR also. So is it that? And if this data is lost, then what impact will it have on the individuals? That is how you also determine the risk. High risk could result from either high probability of some harm or lower possibility of serious harm. See, if there is a high probability that, this data can be lost, and there is a very high probability that this harm can be inflicted upon if the personal data is lost, then it is high risk. Or if you see that there is a lower possibility, for example, you have all your encryptions and everything in place, but you have this medical data and psychiatric data which is highly sensitive in nature, and you have a lower possibility that if this data is breached, then in that case also you do a data protection impact assessment. Because even if 10 of such data is breached, or there is a very less possibility that their data would be breached. If it is breached, it will cause very, very serious harm. Then a data processing impact assessment must be done in those cases. You should, as a privacy officer, consult your data processing protection officer, and where appropriate, individuals and relevant expert. So when you're doing this, and as an organization, you probably don't have a risk officer, you don't know how to do it, then you can also reach out to the data protection authority in your area and ask them that this is the case, and we don't know, we've not had this instance before, we are not sure whether an impact assessment needs to be done or not. Can you please guide us through? And the data protection authority in that region will help you through that. They will not make a whole template of it, but they will help you ascertain whether it is high risk or low risk, and whether you should do a data processing impact assessment or not. If you identify a high risk that you cannot mitigate, you should consult a data protection authority before starting processing. If you see that, you have these data, the psychiatric wards data, and that this is high risk in this case, but you can do nothing that can mitigate or, completely ensure that the data is protected, then in that case, you need to reach out to the data protection authority and seek for their help, that how can we mitigate, or what things can we do so that, we do not become solely liable for this if there is a breach, or how can we prevent the breach. And the data protection authority, if it has had similar cases, they'll give you examples of those cases, or they'll give you some idea around that cases. And whether they charge or not, it depends territory to territory. They might charge you for this consultancy, but they might not also charge you for this consulting, because it's the public office and it is there to help organizations and individuals with privacy compliance. So they might not even charge you for that.